Coming together is a beginning, keeping together is progress, and working together is success. This mantra of working together has brought us here. A very pleasant good afternoon to everyone assembled here. I, Shivangi, have the privilege of taking you through the panel discussion on topic intellectual property rights scenario in India and the world, where we will be talking about the scenarios we need to keep our eyes on. Acropolis Group of Institutions is greatly honored to have special guest of this afternoon. A warm welcome to all. I would like to welcome Mr. Siddhant Parwat, Dr. Ankur Saxena, Ms. Tanu Saxena. Thank you so much for investing your time, valuable time with us today. So, before we dive into the introduction of our panelists, our first panelist is Mr. Siddhant Parwat. He holds fluid and thermal engineering. He is also a registered of intellectual property rights. He is associated with K&S Partners, intellectual property law firm, Gurugram, as a senior associate in patent domain for the last 7 years. He works with corporate clients, reputed foreign IP firm laws, multinationals, startups, and universities to obtain patent protection. Both our second panelist is Dr. Ankur Saxena. He holds a PhD degree in mechanical engineering from IIT Indore with a specialization.
Types of IPR copyrights. So copyrights and trademark, although they sound similar, sometimes the registration marks are also copyright protected, but that's not a right practice. When that your idea is expression protected through copyright, but when your idea is your identity protected through trademarks. That's what I would suggest.
Okay. Ma'am, but as you said, that book or anything that we write could be a copyright. It could be a patent also.
Um, See, it's like, theory you teach to your students and then you take them to laboratory for practical, right? So if in the same way, if your expression, if your idea is
Solution. So it is a very obvious kind of a solution. So it should require little bit hard work, little bit more extra efforts to get to that particular, part over there. So that's the second thing. And the third criteria basically is the industrial applicability. So whatever, you are working on patent, it should be industrially applicable. So we always give an example of, 3 leg socks. So you can say it's a novel thing because it is having 3 legs. It can be, someone can debate that it is not very obvious, it is non-obvious, but it is not industrially applicable. So you cannot able to produce more socks of 3 legs because it is not used by a person in the whole majority. So that's the third criteria, that it should be industrially applicable. So these are the basic 3 criteria which a person should able to met to basically file a patent. Apart from that, there are different sections which talks about non-patentability and other things else. So but if a person who is working in this particular field and he want to file a patent, he basically has to see these 3 simple things. If you fall in within these 3 things, you can basically file a patent application.
Okay. So, sir, if I am writing a technical book, say, so
Yes.
should I go for a patent or should I go for a copyright, sir?
So if
Because
you are writing a
generally in books, I have seen copyright.
So basically, book is for something which is protection of a copyright. So because in patent, first of all, it's a solution to a specific problem. So a book is something which is in length, which is talking about different chapters, different things, and all those taking into scenario. Patent is very specific to a particular, protection and particular problem which they are solving it. So for example, in a book, if you feel that I am providing a solution also, so parallelly, like Khushbu mentioned, you can go for patent filing based on that, but it should be prior to the publication of the book. It's not that your book is published, someone has read it, and they have now starting formulating ideas and filed a patent prior to you. So there can be a multiple things in the IPR. For example, we always take example of mobile phones. Like iPhone is a trademark, and the copyright is the whatever software and algorithms written over it. The programming and the methodology how it is working, it's a patent. The structuring of the phone, it's a design. So a one product has multiple protection, but you should be very smart enough that from where you are getting the more output from that protection. So that's based for the applicant to decide that for which protection he has to go.
Okay. So far we have discussed about the patent, copyright, and the trademark. I have also heard about the plagiarism. So, is plagiarism somewhere related to IPR?
Yes, so ma'am, I would like to add like
Yes.
uh, in plagiarism, as Mr. Noor has told, plagiarism is just a copying of any idea which has been copyrighted, which has been from copyrighted material. Like if you have published a book and some student is copying that idea and using it for its monetary purpose or for publication in any journal, then it can be termed as plagiarism. So there are various tools which can be used to highlight the percentage of plagiarism, which is mostly used in educational institutes.
Okay.
So it is not
So,
a intellectual property, but it is related with copyrights. So we can say it is a part of some uh, IPR
it is a
infringement of
part of
IPR.
IPR, but it is not a
Yes,
type of IPR.
yes.
Okay, thank you. Thank you very much, sir. So, in addition to that, I would also like to know that how intellectual property rights are important for educational institute.
Okay.
Yes, ma'am.
Yes. So we discussed about plagiarism, which plays an important role in educational institute, as Ankur mentioned. So they use lot of tools also, to check plagiarism so that the work is authentic. So that is one thing which he said about relevance of IPR with educational institute. Apart from that, yes, the importance there is lot of importance of IPR for academic institutions, because first thing is IPR awareness. Okay. There should be proper awareness about IPR in all the institutes, so that you can channelize all the innovation in the right direction. And not only that, you can also encourage the researchers and the students there to innovate, and you can add value to it by filing patents. And based on the type of IPR which is generated, you can even file it, and students can also have that in their resume as their extra effort which they have put apart from the studies which they have done. So all this will happen only if everyone is properly aware, like what kind of IPR they are generating and how it is important to document it properly, so that later point of time they can file a patent or any relevant IPR for the subject matter.
Okay. Okay, fine. So, ma'am, like if a student has done something which is very unique and he wants to go for a patent. So, can you please tell us the filing procedure, patent filing procedure for the same?
Yes. If the student or any inventor feels that they have done some unique work, so the first step would be to check the uniqueness or novelty of that invention or the idea. So as Siddharth already mentioned, that novelty is one of the criteria to file a patent. So the first step would be to assess the novelty of the invention in hand, which we do using various patent search databases. So we search worldwide based on the novel feature of the invention. We do a worldwide patent search. So once that is done and we are sure that the invention has some novel features, then we can go for the drafting of the patent application, wherein we have to claim the novel features properly, and then we can file it with the Indian Patent Office. So these are the basic steps of the patent filing.
Okay, ma'am, how long does it take to get the patent?
Patent normally 2 to 2.5 years. Within that, we can expect the final decision. So basically, we file the patent, then the patent office will examine it. If they have any objection, they send us the FER, examination report. We have to respond to the examination report. If they are satisfied, they can take the decision. Otherwise, they can call us for hearing.
So in hearing, we face to face we discuss with the controller about the particular patent case. Based on that, they take the final decision. So all this within 2 years you can expect to happen. Otherwise, there are other provisions also with patent office like expedited examination, early publication. So if you opt for those provisions, then it can speeden up the process. You can expect all this to happen within a year or 1 year, 1.5 years, like that.
Okay, but since 2 or 2.5 years is a very long time, what if I have gone for filing a patent, but meanwhile someone else uses my innovation? So is that legal? Like someone can do that?
No, no, there is a solution to that, because see, I agree that to get the grant of the patent, it takes a lot of time. But when we file a patent, immediately we get a patent application number. So the inventors can use this patent application number. They can even use patent pending label. So it is kind of a notification to general public saying that it is a patented technology which belongs to me. So nobody can copy it. So the moment you file the patent, you own it. You own the invention. So nobody will copy it.
Oh.
So yes.
And any other speaker who wants to add something to that? Yes,
Yeah,
ma'am.
I would like to add to the question that you asked, like why is IP, knowing IP important for academician?
Yes, ma'am.
So I would like to add a little to it that in the whole research that is going on in India, or for that matter in world, maybe 50% is coming from R&D sectors of private and government research laboratories, but almost somewhere around 20 to 22% is coming from academic institutes, because academicians are not only involved in teaching but also in research. And what happens is when we are as an academician inventing something, we end up like just protecting our or just publishing it, and that's we feel like achievement to our invention. But being aware of the situation that you can actually protect your invention, it is okay to publish a few of your research works, but for the other few you should have them protected and then publish it. So that's very important for any academician to know when they are researching, when they are a researcher as well. And the another point is that as an academician, we invent many things, but we are not capable of converting them into a marketable product many a times. And that is when we get limited of situations. We are limiting of manpower, or money, or time, or that much. We don't want to get into all those marketing things. But what you can do that time is we can protect our invention through IPRs, and then we can sell them, or we can give them to the proper people who are able to market it, who are actually interested in marketing it. So that is where we lag behind. That as an academician we think like, okay, I am not able to produce it, I'm not able to market it, so why to protect it? I would just publish it and sit back. So that's not correct. Actually, you protect it. Even though if you are not able to produce it or market it, there are people who are interested and they can buy it from you. It's like having an extra house, because I just own a house. Why not? I why wouldn't I have one more house? Because somebody may be interested in renting it, selling it, purchasing it, anything. So if even if you're not interested in marketing it, do protect, because somebody else may be interested, and that may be a source of income and credit to you also.
That
So
is
that
very true, ma'am. We
so
actually, when we do something, we directly go for publishing. We don't even think of protecting. This is really new thing that we have learned so far. But can you please tell us that if I want to go for publishing, as you said, first we have to protect and then publish something. So how can we do that?
uh, yeah, that's a basic proper way that protect before you publish. That's a very common terminology we all know it so far. But yes, Indian Patent Act still gives you 1 year time if you have published it. not a problem if you have published it in a research journal or in such kind of things wherein like we go for grants and all those things, CSR and all those kind of grants, and if you have published in there, you still have a period of 1 year during which you can file a patent, but it's always safe to protect it first file the patent and then you are free to publish. Publication will give you credits, your research publications, but IPs will give you credit as well as monetary benefit. So that's something should be known to all the academicians.
Okay, thank you, ma'am.
So just adding to what Ms. Khushbu was mentioning, so in
Sure,
the
sir.
Patent Act, also, we have a provisional filing and a complete filing. So, for
Okay.
example, if you are working in a journal and you wish to publish it, so what you can do, you can at least file a provisional application and then go for the journal filing and just file it. And by that time, 1 year is passed, you can work on that particular part and then file a complete, so that you can have your protection of the patent also. In the meantime, you can have your publication also. So it's better to start together. You file a provisional, you go for your publication. In the meantime, your publication, if it is filed, because your filing date of patent is prior to the publication, so
Right.
you will not be having any problem because your priority date is very much secured. So we can do that way, because it's a general perception in the education institute time, because we are very much, what I say, that to publish it, once you get a good results, good values, we are very much, very much enthusiastic, let's file the publication. So we have to just hold our enthusiasm a little bit more and just file a patent and then go for publication with that journal.
Okay. That
And there
that's
one most encouraging point is till now academic institutes were in the highest paying band of the fees band
Mhm.
according to Indian Patents Act. But in the
Correct.
September 21, according to the newest amendment mentioned, now academic institutes have come to the lowest paying band of it.
Hmm.
So you are
Hmm.
getting actually 80% discount on what you were already actually paying earlier. So that's a big encouragement given by Indian government, and that's why I think academicians must uh, start innovating, and they are already innovating, but start protecting their innovations.
that is really great they have done.
So I would like to add one more point here,
Yes,
that
ma'am.
with respect to institutes, we spoke about 80% rebate given to the institute from the government. Also, if there is any female inventor involved, you can even apply for expedited examination. So that provision also can be availed. So
Okay.
basically, if you're properly aware about the IPR provisions and the way to proceed, it can be a very effective channel. And also, if you are able to commercialize it, as Khushbu mentioned, if you are able to, bring the product in the market, then it can add to another revenue stream.
That's right. Like in continuation with this, my next question would be, what are the roles and responsibilities of intellectual property right professionals?
Okay, so I will answer to it.
Sure, sure, sir.
So, IP professionals. So the basic job is to properly guide the inventors and applicants for what is the how they can achieve better protection for their innovation, and like to get a maximum, like you can, and any applicant can file a patent by himself, but if you will take an help of IP professional, he will ensure that maximum benefits can be achieved. And the actually the claims which are drafted, they are drafted keeping in mind to achieve a maximum benefits for the applicant or the patentee. So all these things, if IP professional, he is much more familiar with the concepts, the law which are uh, act which is governing the IP Act or IP rules. So taking a help of IP professional is always advisable, and their basic fundamental responsibility is just to give maximum protection to the innovation or invention, and for the work for the benefit of applicant.
Okay. So if someone wants to become an IPR professional, so how can we do that?
So basically, patent office, it conducts a patent agent examination. So if you really want to have spent time in this particular field and you see your career, for some times, so it's always advisable to, register for that examination and give that exam and be a registered patent agent. Like, in the like Miss Tanu is there, Khushbu is there. So we and me, myself, and we all are registered patent agent because we are practicing in this field. So if you want really have an interest and you feel that, yes, I can contribute. See, because in patents now, what happens that you are working in the core domain, you are working with technology. So patent is something which every institute files first or every company. So you are basically knowledgeable of the content which is coming in the market 3 to 4 years later. So it's basically your advancement in your particular knowledge also. So it gives that to you. So if you want to have a good career in this particular field, so first is that you give your agent examination, pass it. And even if you are not, not very much sure that whether I have to spend this time with that, so there are many multiple organizations who hire, freshers from the BTEC's time, because we all were hired when we are not an agent. From my firm, I can tell you. So that said, opportunity is given to many institutes, many firms. If you have interest, many internship programs are also there, and there are multiple colleges also. Like, IIT Kharagpur, they have one course of 3 years. Then Nelsar is there in Bangalore. So apart from that, then IGNU also, if you want to have an open schooling course, IGNU also provide that course. So these are colleges give you the, basic framework and the, also to make your career in this particular field.
Okay. Any other who wants to add to it? Yes, ma'am.
Yeah, other than this, not only patent agent, if you like are very fascinated towards a government job, then Indian Patent Office is also very depriving of manpower. And there you have many posts, including IP examiner, patent and design examiners also. And for that also, you just have to have a technical background and nothing else. Obviously, you have to give some exams and qualify them, but that's also a very good very good career prospect in IP field, that you can have a government job, which is a good paying, good secure job, and you just need to have a technical background. And whenever the positions are opened, you can apply them, and it happens in a couple of stages, similarly as it happens in case of patent agents. But that give you a government job. You don't need to have your office or anything or practicing privately. It would give you a secured paying job.
That's thank you, ma'am. If someone
I
wants
would
to,
like to add
yes, ma'am.
here.
Yes, ma'am. Please.
So the patent agent uh, patent agent aspect and the examiner thing has been told. So there is one more thing which I would like to add here, like a person who would like to, who is more inclined to go towards patent searches and market analysis and valuation of the technology. So that area is also there, which is not very much explored also. So there are courses available, using that people can be aware like how to do patent search and how to do market analysis, market research. So that area is also there under IPR, which can be taken up.
Okay, thank you, ma'am. Like if someone has already taken the like IPR, so how one should, why or should we protect our intellectual property after the IPR has been filed, or we just have to sit back and relax? If I have I have filed a patent of something, say a paper or my research work. So now I just have to sit back and relax, or I have some other responsibilities that I have to go through.
Yes,
Yeah.
definitely. So, uh, I just want to be clear. Your question is, once you file a patent, after that, do you have other
Yes,
responsibilities?
yes, ma'am. Yes, ma'am.
Yes, yes. So, yes, not entirely your. If you're taking the help of a, any patent attorney, then they will advise you and guide you with all those steps. So once a patent is filed, then as I mentioned, that your patent application will be examined in the patent office, and they might send objections. So that time, the attorney will discuss with you regarding more technical features or technical advantages which the invention has, and they will try to convince with their argument uh, uh, they would convince the controller with their arguments that no, this particular invention has technical advantages over the cited patents. Then once the patent is granted, also after that also you have to maintain the patent. So you have to pay the annual fees to keep it alive and enforced. So these are few things which will be coming up after you file the patent also.
Okay, that is why we heard that it is given for a particular time period.
Yes, 20 years.
Yeah, for 20 years.
Okay.
So once your patent is granted, you have to maintain it for 20 years. So then that is also a specific deadline by which you have to, maintain that particular part as well.
Okay. Okay. And I have heard a lot about Patent Act of 1970. Can I get the brief about that? What is Patent Act 1970?
So basically, patent act. So patent is governed by that particular act. So whatever, like Mr. was mentioning, it goes for the examination, it goes for the grant, we draft it. So it's a set of procedure and set of steps that a person should take care and should be aware from filing till the grant and after that. So it's a complete act which the agents, the examiner, the controllers, even the courts, if your case goes to the courts also, so that's the basically a book or an act by which all the things are monitored, governed. So when the examination should be done, how much timeline is there to file its reply, how hearing should be appointed. So basically it talks about from the starting of the drafting till the grant, then after the grant also, and in case you lapse your patent, so how you can able to restore your patent. In case someone is infringing your patent, so then how you can tackle with that. So these are all set of guidelines and all this set of procedure very much in detail is mentioned in this particular act, and the person who want to understand in this particular field can able to read it and basically understand it, that how we have to take it forward from the drafting till the filing then examination. So all the set of acts and rules are present in this particular act.
Anyone else who would like to add? Okay. So my final question would be like, if our college wants to set up an IPR cell, so how can we do that, sir?
Yes, so uh, IPR cell means there should be some dedicated IPR experts there who should guide the college or maybe the respective departments regarding the IPR, creation, documentation, and filing. So basically, there will be three things which each researcher or the inventor should be aware of, like what kind of IPR they are generating, whether they are properly documenting it, and then comes the role of the IPR professional who can guide them to take file the patents or trademark or copyright as per the nature of the work generated. So the main role here would be to generate IPR awareness and encourage the students and researchers to, innovate more.
Yeah. Further to it,
Yes, sir.
I would like to add further.
Please,
Like,
please.
yes, so if you are planning to set up an IPR cell, so I believe for NAC and as well as NBA accreditation also, there are some criteria like criteria 3 for NAC, which I believe during my teaching tenure we were working on it. So it is also giving some importance as well as some additional points if the college is having some IPR cell. So you can like the as Mr. Nu has already mentioned, the basic function of that IPR cell is to provide awareness between the faculty members as well as students. There are many good projects which students have developed, but since they have no awareness about it,
Actually,
those projects got wasted. So if
yes.
a IPR cell is set up, and then they can give the like regularly having some discussions, calling some external experts in this field. They can do such a thing. Also for NPTEL, I believe in NPTEL there are few courses for understanding the IPR as well as patent. So that can be taken by students as well as faculty members to improve their awareness. Basically, the institution, it is a collection of young minds which are filled with n number of ideas. The only thing is, if you guide them in a right direction, you will get n number of patents, trademarks, industrial design. The only thing is, a person should be aware about how to guide them, how to answer their queries. So the basic object of that IPR cell would be a person who is responsible to answer each and every question uh, of students as well as faculty members. So keeping this thing in mind, we can set up a IPR cell in our institution, or like whatever we are planning. So this is my.
Thank you, sir. Thank you very much.
So, adding to Anku's point, one
Yes,
point
sir.
from my side, like, in third year and fourth year of engineering, so normally we have a projects which we have to work on in fourth year specifically. So in that, working of the project, we have to deal with many problems, and when thing we particularly provide some more solution in that particular project. So, having that IPR cell, it will give that students a confidence that, since I am in my final year of graduation, I'm working on this project. Why not I start, doing a patents filing or some trademark or some design registration within that tenure itself. So, that particular IPR cell can able to monitor the important projects with the particular, faculty members, with students. It's a group of 4 to 5 students with a faculty member who works on those projects in a years of time. So on that particular partner, they can basically generate some IPR during their 1 year of tenure in the fourth year itself. So having that IPR cell, which will boost them also to going forward and filing of the patent.
Thank you, sir. My last question would be: is it necessary to associate an IPR professional with the IPR cell, or we can directly go for framing a IPR cell?
Um, Actually, Indian Patent Act doesn't mandate any patent practitioner to be intervening. Any inventor can do or protect his or her invention on his own. But we would suggest you to have a practitioner in between is because it is a techno legal branch. It is having, if you like read a research paper, you would understand it. But if you read a patent article, if you read a published patent, you will not understand it as much because it is written in a techno legal language, and the whole process goes through a techno legal process. Okay, so as academicians, we are expert in techniques, we are expert in technology, but somewhere we are not that much aware about the laws governing IPRs, where the IPR professionals are expert of those. uh, you may not be knowing that to be a IP agent, we have to have a technical background. So every IP professional practicing right now is having technical as well as legal background to be that to qualify that exam. Okay, so that is why we suggest you to have a IP practitioner in between, but it is definitely not mandatory. If you have set up right policies, you are aware of the right governing agencies, and you even take help on a on some occasional basis, then also colleges and institutes can run their IP cell on their own.
Thank you, ma'am. Okay, fine. So moving with this, we had enough of discussion. We had so much knowledge about IPR, other terminologies, how do we file a patent, and everything. So in continuing, I'm handling over to Shivangi. Shivangi, please.
Thank you, ma'am. Students are requested to check the provided link for feedback and attendance. Thank you, ma'am. Thank you, sir. This session was really informative and we look forward for more such sessions. Last but not the least, I now invite Professor Anita Mahajan to propose vote of thanks.
Thank you. Good afternoon to one and all present here. It is such an honor to get the opportunity to thank you all dignitaries. On behalf of Computer Science and Engineering Department, Acropolis Institute of Technology and Research, I, Dr. Anita Mahajan, would like to express my gratitude to all the esteemed panelists of the panel discussion for their presence and contribution to make this session a great success. A warm thanks to Ms. Tanu Singh, Ms. Khushbu Bardia, Dr. Ankur Saxena, and Mr. Siddhant Parvat sir for such an successful event. I would like to extend my gratitude to the Acropolis management. A heartfelt thanks to respected Director Sir Dr. S.C. Sharma. A special thanks to our Head of the Department Dr. Kamal Sethi sir for providing immense support to making this event successful. I would like to extend my gratitude to the organizing team, student team, as well as Mahen sir and Rupi ma'am, who systematized a panel discussion on such trending and ambit subject. Heartily thanks to all the participants to make this section successful. Thanks to all once again. Thank
Thank
you.
Thank you. Thank you.
Yeah. Thank you all.
Thank you for having us.
Thank you all. It was nice to be here and share our views on the World IPR Day. So,
Right. Yeah.
Yeah.
Thank you, ma'am. Thank you, sir.
Okay. Have a nice day. Bye.
Yeah.
bye.
Okay. Take care. Bye.